Hello, and welcome to this ABA Commission on Immigration presentation on the Biden administration's June 18, 2024 announcement of new executive actions to keep families together. My name is Dina Sharouk, and I am a senior legal advisor to the ABA Commission on Immigration. After watching this video, you will have a better understanding of the new executive actions taken by the Biden administration to provide lawful immigration pathways for some undocumented spouses and stepchildren of U.S. citizens, as well as employment-based visas for eligible individuals, including those with DACA and other Dreamers who have graduated from accredited U.S. institutions of higher education. You'll learn what the policy does, who may qualify, and how it will benefit those who do qualify. Let's get started. On June 18, 2024, the Biden administration announced new executive actions aimed at keeping American families with mixed immigration statuses together, as well as easing the visa process for U.S. college graduates, including Dreamers. Here's what the executive actions do. The first action allows certain spouses of U.S. citizens who entered the United States without authorization and who lack immigration status to apply for lawful permanent residence, referred to as a green card, without having to leave the United States through a process called parole in place. Normally, undocumented spouses of U.S. citizens who entered the United States without authorization would have to apply for a case-by-case discretionary waiver in the United States before being required to leave the country and wait abroad to be processed for lawful permanent residence. The process to obtain a waiver can take several years. Under this executive action, DHS will establish a new process for some undocumented spouses to apply for parole, and if granted, would allow them to be eligible for work authorization and to apply for permanent residence without having to leave the United States. Additionally, some undocumented stepchildren of U.S. citizens may also apply for residence under this process. The second action permits DHS and the Department of State to facilitate some employment-based non-immigrant visas for eligible individuals who include those with deferred action for childhood arrivals, or DACA recipients, and other undocumented individuals who have graduated from a U.S. institution of higher education and who have a job offer from a U.S. employer in a field related to their degree. Waivers for eligible individuals will be expedited on a case-by-case basis. So who qualifies for these processes? Each of these cases will be decided individually, which means that no one is entitled to the benefit. It is in DHS's discretion whether to grant the applicant parole or a waiver. For parole in place, undocumented spouses must meet the following eligibility qualifications. They must be present in the United States without admission or parole. This means that they've entered the United States without authorization. They must have been continuously present in the United States for at least 10 years as of June 17, 2024. They must have a legally valid marriage to a U.S. citizen as of June 17, 2024. In addition, the non-citizen spouse cannot have any disqualifying criminal history or be considered a threat to national security or public safety. For undocumented stepchildren of United States citizens, they would have to be physically present in the United States without admission or parole. They must also be unmarried and under 21, and the marriage between the parents had to have taken place before the child turned 18. Similarly, the stepchild cannot have a disqualifying criminal history or be considered a threat to national security or public safety. Once parole is issued, family members will need to apply for lawful permanent residence within 3 years. For the employment-based visas, applicants will include DACA recipients and undocumented non-citizens who graduated from an accredited U.S. institution of higher education. They will need to have a job offer for a job in line with their area of study from that institution. The applicants will have to be processed by a consulate, which means they will need to apply for a visa and leave the United States to be interviewed at a consulate before they can return to the U.S. with the visa. What can someone do now if they may be eligible? It's important to note that the exact details of these processes haven't been revealed, and as of the date of this video, they have not yet come into effect. There is no application to submit at this time. These processes are expected to come into effect before the end of the summer of 2024 after a notice has been published in the Federal Register. The Department of State will be updating their guidance for employment-based visas. If you are interested in applying for any of these benefits, you should consult with a licensed immigration attorney or Department of Justice accredited representative. Potential applicants can start collecting documents now to prove they qualify for the benefit. For example, if an applicant may be eligible for parole in place as a spouse of a U.S. citizen, they can collect proof of their physical presence in the United States. These are any documents that show that the applicant was physically in the United States during that time period. This could include lease agreements, rent checks, bank statements, and utility bills. Documents should be in English. If they are not, they will need to be translated by someone who is competent to translate from the language of the original document into English. These programs will require fees. Although the amount is unknown at this time, families should take steps to save for any costs associated with the process. Let's talk about the potential impact of these policies. DHS estimates that approximately 500,000 non-citizen spouses of U.S. citizens could be eligible to apply for a green card under this new policy. Additionally, 50,000 stepchildren of U.S. citizen parents are estimated to qualify. With respect to employment-based opportunities, the President's Alliance on Higher Education reports that there are presently 400,000 undocumented students enrolled in higher education in the United States at the graduate and undergraduate levels. This does not account for undocumented individuals who have already graduated from higher education institutions. This policy is aimed to keep families of U.S. citizens together in the United States without the fear of deportation. Further, the policy stands to meet the needs of the labor market and bolster the economy. It is important to note that these proposed policies, like all policies, could become the subject of litigation in the future and are at risk of being blocked. Practitioners should verify the status of the policy before advising clients or submitting any applications. Thank you for watching this video brought to you by the American Bar Association's Commission on Immigration. If you have any questions regarding this video, reach out to us at the Commission on Immigration at imcenter@americanbar.org. Thank you and be well.